Good day, sir. We are the Chapter 8 reporters. So, I am Albert Sornyot, and I will be reporting the introduction and so on. The PNP General Policy and Guidelines on Dispute Resolution, Public Assembly and Demolition, Ejectment Order. So, we are going to follow into the dispute resolution. Dispute resolution is one of the functions of a sound political system. It refers to a number of processes used to resolve dispute between parties. So the dispute is a disagreement, argument, or controversies that gives rise to a legal proceedings such as arbitration, mediation, or lawsuit. There are many types of disputes. Example, including the family, neighborhood, employment, business, housing, and personal injury, securities in consumer, and environment disputes. They are the examples of the disagreement argument. And for the types of dispute resolution, we have the litigation, refers to the process of resolving disputes. This is the processing to resolve the disputes of filing or answering a complaint through the public court system. And we have also the alternative dispute resolution, refers to the procedure for settling disputes without litigation such as arbitration, mediation, or negotiation. And for the next slides, for the alternative dispute resolution systems in the Philippines. According to the Alternative Dispute Resolution Act of 2004, Alternative Dispute Resolution System refers to any process or procedure used to resolve a dispute or controversy other than by adjudication of presiding judge of a court or an officer of a government agency as defined. So in this act, in which a neutral third party to participate to assist in the resolution of issues, which includes the arbitration, mediation, and conciliation. Early neutral evaluation, mini trial, or any combination. For the types of alternative dispute resolution, we have the three dispute resolution. There are arbitration, mediation, and conciliation. For the arbitration, it is a voluntary dispute resolution process in which one or more arbitrators appointed in accordance with the agreement of the parties or rules promulgated pursuant to the Alternative Dispute Resolution Act of 2004. For the arbitrator, it is a person appointed to render an award or a person to give a solution for the problem. And for the award, it is a partial or final decision by the arbitrator. For the mediation, the mediator is the voluntary process in which a mediator elected by the disputing parties facilitates communication and negotiation in asserting parties. This is the process where the neutral third party helps two or more people or groups resolve a dispute facilitating communication and negotiation. The mediator does not have the power to force a settlement, but instead guides the parties toward creating their own agreement. That's the mediation. For the third, the conciliation. The conciliation is the negotiation. This is the act or process of ending a disagreement or conflict between the two parties. So, often through discussion to achieve mutual acceptable outcome, it typically involves a neutral third party to call the conciliation, who helps the disputing parties lower tensions and improve communications to find a peaceful resolution for the problem.
Good day, sir. I am Diniboy Arpas. I am reporting labor dispute. Labor dispute refers to any controversy or matter concerning terms and condition of employment or the association or representation of person in negotiating, fixing, maintaining, charging, or arranging the terms and condition of employment regardless of whether the disputants stand in the proximate relation of employer and employee. Employees have the right to self-organization and the form join or assist bargaining through representative of their own choosing and to engage in concerted activities for the purpose of collective bargaining and other mutual aid or protection. Republic Act 87 5 1953 Section 3. A labor dispute is a conflict between workers and employees about wage benefits, working condition, or representation. Workers also have the right to organize, form unions, and choosing their representative to negotiate for better condition. Example, employees demand a salary increase because of rising prices, but the employer refuses. Strikes, picketing, and lockouts. Labor dispute can lead to labor strikes and or lockout. Strikes refers to any temporary stoppage of work by the concerted action of the employees as a result of an industrial or labor dispute. RA 6715 in 1989, Section 4, whereas a lockout is the temporary refusal of an employer to furnish work as a result of an industrial or labor dispute. RA 6715, 1989, Section 4, two grounds for the valid exercise of the right to strike or lockout, namely Chan Robles Virtual or Law Library 2002. Speaking of strike, a strike is when workers temporarily stop working together to fight for their rights or benefits during a labor dispute. Example, workers in a factory are not giving safety equipment. They talk to management but nothing changes. To pressure the employer, the workers decide to stop working. This work stoppage is called a strike. And a lockout is when the employer temporarily refuses to give work to employees because of a labor dispute. Example, employees in a company keep protesting for higher pay. The employer disagrees and instead of allowing them to work, temporarily shuts down the company to pressure the employees. This is called a lockout. And the next is different form of labor strike. Legal strike. Legal strike, one called for a valid purpose and conducted through means allowed by law. Example is workers file notice and vote before striking for higher pay. Number 2 is illegal strike. One stage for a purpose not recognized by law or if for a valid purpose conducted through means not sanctioned by law. Example, employees suddenly work out without filing notice. And number 3, economic strikes. Economic strike, one stage by workers to force wage or other economic concessions from the employer which he is not required by law to grant. Example is supermarket. Employees strikes to ask for salary increase. And number 4 is unfair labor practice or ULP strikes. One call to protest against the employer acts of unfair practice and enumerated in Article 248 of the Labor Code as amended, including gross violation of the collective bargaining agreement and union busting. Example is workers strike because union leaders were fired. Number 5, slow down strike. Slow down strike, one stage without the workers quitting their work but by merely slackening or by reducing their normal workout output. Example, delivery riders delay services on purpose. Number 7, wildcat strike. Wildcat strike on declared and staged without filing the required notice of strike and without the majority approval of the recognized bargaining agent. Example is a group of workers stop working without informing their union. And the last one is set down strike. One where the workers stop working but do not leave their place of work. Example is factory workers set aside the workplace and don't leave. Legal requirements in conducting strike and lockouts. A strike or lockout notice shall be filed with the Labor Department at least 15 days if the issues raised are unfair labor practice, or at least 30 days if the issue involve bargaining deadlock. Notice workers or employers must file a written notice to the Department of Labor or DOLE 15 days before if it's about unfair labor practice, 30 days before if it's about bargaining deadlock. Number 2, the strike or lockout shall be supported by a majority vote of the members of the board of directors of the union or of the members of the board of directors of corporation or association of partnership obtained by secret ballot in meeting called for the purpose. Voting a strike or lockout must be approved by the majority. For workers, majority of union members must vote yes in a secret ballot. And for employers, majority of the board of directors must agree. Number 3, strike or lockout vote shall be reported to the Labor Department at least 7 days before the intended strike or lockout. Report of the vote. The result of the voting must be reported to the DOLE at least 7 days before the planned strike or lockout. Unfair labor practice. According to the Labor Code of the Philippines 1974, unfair labor practice violate the constitutional rights of workers and employees to self-organization, are inimical to the legitimate interests of both labor and management, including their right to bargain collectively and otherwise deal with each other in an atmosphere of freedom and mutual respect. This disrupt industrial peace and hinder the promotion of healthy and stable labor management relation. Example, a company threatens to fire employees if they join a union. This is unfair labor practice and workers may strike because their rights are violated.
Good day, sir. I am Christian Aquino. I am reporting the collective bargaining agreement. The collective bargaining agreement, CBA, is a contract executed upon request of either the employer or the exclusive bargaining representative of the employees incorporating the agreement reached after negotiation with respect to wage, hours of work, and all other terms and conditions of employment. Collective bargaining is a legally binding contract between an employer and a labor union or worker association. Procedure in collective bargaining. The following procedure must be covered in Collective Bargaining Republic Act 6175 1989 Section 20. PNP General Policy and Guidelines on Labor Disputes. According to the PNP Operational Procedure Manual 2021, the general policy and guidelines of all PNP personnel are as follows. PNP 2021 P150 151. Public assemblies, rallies, and demonstration. Public assembly refers to any rally, demonstration, march, parade, procession, or any other form of mass or concerted action held in public place for the purpose of presenting a lawful cause or expressing an opinion to the general public. Freedom, peaceful assembly is a basic human right that should be enjoyed and exercised by individuals and group, unregistered association, legal entities, and corporate bodies. Assemblies serve a purpose. This is the gathering of people to fight their right about what they want. Public assemblies permit application requirement. It is important to note that a written permit shall be required for any person or person to organize and hold a public assembly in public place. However, no permit shall be required if the public assembly shall be done or made in a Freedom Park or duly established by law or ordinance, or in private property, in which case only the possession is required, or in the campus of government, owned and operated educational institution, which shall be subject to the rules and regulation of said educational institution. All gathering and or any person shall have the permit to organize public assemblies.
Good day, sir. I'm Antonio Aldunas III, and today I'm reporting the PNP General Guidelines on Rallies and Demonstrations, Civil Disturbance Management Operations, CDM Operational Task. And the first is isolate the area, second, secure likely targets, and the third is control the crowds, fourth is establish area control, and the last is arrest violators. The next is general guidelines. General guidelines with the holding of public assembly to ensure public safety. CDM, the PNP units tasked to maintain peace and order shall not interfere at least 100 meters away from the place where the public assembly is contingent under the command of a PCO shall be detailed and station being held. So the general guidelines are the basic rules or principle that guide how people or an organization like the PNP should act and perform their duties. They serve as a general reminder to do things properly, fairly, and legally. The next is public responses. Number 1, during planning stage. A. Initiate dialogue with the leaders or organizers to ensure the peaceful holding of a public assembly. So, the number 1 is police responses are actions taken by the police when a crime or incident or emergency happens. The next is police response number 2. During initial and peaceful stage. A. With permit or held in freedom parks, private properties. So, the police response number 2 are how the people react and act to keep people safe during crimes or emergencies.
Good day, sir. I am Rincy Pitogo and I will be the reporter of Demolition and Ejectment Order. Demolition refers to the dismantling by the local government of LGU, any legalized authorized agency or personnel of the government of all structures within the premises subject for clearing. According to the Urban Development and Housing Act of 1992, eviction of demolition as a practice shall be discouraged. Eviction or violation, however, may be allowed under the following situations. Demolition and ejectment order is illegal from the court or local government order that requires people and vacate land to property. They are occupying illegal and it's an order to remove people and structures from a land they have not legal right to occupy. Role of the PNP in the enforcement of demolition and ejectment order. According to the PNP Personnel Procedure Manual 2021, the role of the PNP in the enforcement of demolition and ejectment order follow as police assistant in information or implementation. So the role of the PNP here is the PNP demolition or ejectment order. The police do not carry out the demolition themselves. The PNP rules is to keep the demolition safe, peaceful, and orderly, not to demolish the structures themselves. So we will move on and we'll go to the next topic. Procedure in the enforcement of a demolition and or ejectment order. Here are the enforcement procedure in the demolition or an ejectment order. A. Rest and treat assessment shall be conducted. B. The PNP personnel shall be informed of the prevailing situation in their tasks. C. Strict observation of human rights. And D. As much as practicable, the CAP shall lead the PNP containment detail. And the last one is E. All PNP personnel involved shall desist from the use of any unnecessary force or any act of harm or harass. So there are they have other procedure from the enforcement of demolition and ejectment order. The letter F is the mode of participation shall be limited to the maintenance of the peace and order during the entire demolition ejectment activity. And the letter G is tear gas, water cannons, and reasonable force shall be used only when all together peaceful and non-violent means have to be exhausted. And the letter H is any PNP member whose family are affected with the demolition or ejectment shall be adhered to other issues or by competent authority. And letter I, the CAP shall ensure the presence of fire and medical teams in the activity area. So the procedure of the enforcement and demolition or ejectment order is issue order, serve notice, prepare, and enforce with a PNP percent, and maintain peace. So they explain here that if the PNP member have a family affected, the PNP member has shall adhere or other issue for other competent. So the last topic of my is lupon. Primarily refers to the lupon or tagapagpamayapa in other term. A council within the Philippines barangay justice system that handles the mediation and arbitration and local disputes, aiming for amicable and low-cost resolution. Composition chaired by the punong barangay chairperson. It consists 10 to 20 members who are respectively individuals in the community. The Local Government Code of 1991, Republic Act 7160 is a Philippine law of decentralized power from the national government to local government unit LGU. In short, the lupon or tagapagpamayapa is a group of every barangay that helps settle disputes of conflicts peacefully without going to court. The lupon is a from barangay team that helps people that problem solve peacefully instead of filing cases in the court. That's I. Thank you.